Yes, Lordship. Lordship, I beg to make a mention for item 7, Your Lordship. Doctrine Council is not available, Your Lordship, today. So, Dithaba.
7. Is the state involved here?
Yes, Lordship.
Oh, that
Union also, Your Lordship.
that notification.
Yes, sir. State is there. State is there also.
State is a former party.
No, no, sorry. Interesting party. Interesting party, sir. State has no.
Yes.
No objection, Lordship.
You don't even know.
Lordship, it's with my colleague.
Some other colleagues. Since I thought I was there in the court.
No, I think this is with regard to the
That exemption,
EPF,
Your Lordship.
exemption.
EPF, Lordship, exemption.
exemption. Okay, not the EPF matter.
No, Your Lordship. EPF matter is item number 1, Your Lordship.
On pre-made by the petitioner. This is matter up to 2 weeks.
Similar pray for item 10, Your Lordship.
Then I don't think so.
Then, Your Lordship, this Your Lordship has directed us to settle the matter with the
Nothing will come out of it.
Lordship. We are working on that, Your Lordship. So we need some more time in this.
We are still teaching.
No, no, my lord. It is out of, they have terminated me.
Terminated.
Yes, as per the court order, that termination order was set aside and quashed.
Yeah, no. What? Okay, there was no stay order initially.
Lordship,
So I am suffering for that reason, my lord, only for review. I cannot join the school.
Private respondent is there.
No, my lord. That is private respondent.
They are the
are-
private respondent.
Yes,
Okay, they have come on review.
yes, my lord. Always taking time.
give us another 2 weeks time, Your Lordship.
Why? This is, the court has
It's
made it
under
very
the process,
clear.
Lordship.
It's a review matter.
They are taking
Nothing-
turns also.
Nothing is there. Nothing is there.
Last time my friend took. Now
No, that time I was suffering that one for coughing and all fever. Only one time I have
You are
taken.
suffering in all respects.
Yes.
I'm going to bring you.
Review matter is nothing. It's it's whether it's there or not. Whether case is made out or not. Simple as that.
Since last year, my lord, to
Yes.
continue. And that is too much.
Friday we will.
So we'll keep it next week.
2 weeks, Lordship. We will.
No, no, my
Try
lord.
There will
It
be a
is,
definite date. No more adjournment.
Lordship.
Yes.
If you seek for adjournment, I'll impose heavy cost.
yes, my lord.
All
Yes.
the back wages that you used to get, you'll
Yes.
pay that cost.
Yes, my lord. Then so they will not take time, my lord.
It will justify it.
Yes.
Yes. Learned counsel for the review petitioner has sought for accommodation on the ground that the learned conducting counsel, learned senior conducting counsel is not available. Mr. H.R. Jerika, learned counsel for the respondent, has objected to the prayer made on the ground that the matter has been lingering for almost a year, only at this stage. This court has considered the submission made and has deemed it fit to allow the prayer made by the review petitioner. However, it is made clear that this matter will be finally heard on the next date fix, for which the parties have to make necessary arrangement for the same. This is matter to 2 weeks.
Definitely.
I beg to mention item number 11, Lordship. It is better, I may come after 3 weeks, Lordship, because in the meantime I will complete the other this rejoinder which was listed yesterday. I will inform the other side.
On permit by the petitioner. This is matter of the 3 weeks.
Highly.
From supplement.
Please, Lordship. Sorry, Lordship. Lordship, I beg to mention item 6.
Who's petitioner?
Yes, I'm a petitioner.
Also 2020 matter.
Lordship, can I have a short date? We can finish it in the next day, Lordship. So that today we don't.
Date, long date makes no difference because next time around somebody will come and say.
I agree, Lordship.
No?
Lordship, if the learned CGAs are prepared, I'll keep myself prepared. I'll finish this matter, Lordship, next week.
Accommodation has been sought for on behalf of the state respondent, to which the petitioner has no objection. As prayed for, this is matter up to 2 weeks.
I will oblige.
From supplementary cause list, item number 1.
Lordship, I'm moving this anticipatory bail in respect of Shalang PS case number 3912 of 2022. Lordship, in this same case, almost 29 other accused have already been granted anticipatory bail by the full bench on 29th. Lordship, my case is that I had entered into a partnership agreement with Yash Coke. If I may have your Lordship to page number 18, Lordship.
Where's the order of the full bench?
I'm sorry, Lordship, by the time we had filed, the order was not uploaded. I have a copy of it. May I, Lordship?
Tell me.
Lordship, I wasn't one of the petitioners who had approached the Supreme Court. Thus, my matter has not been listed before the full bench. However, the issue involving is the same, Lordship. Lordship, my case is, Lordship, at page 18, Lordship. Lordship, I had entered into a partnership with Yash Coke. I am Sumit Kumar Agarwal, Lordship. This was in the year 2019, Lordship. Post this, Lordship, COVID had come and we had applied for CTE and CTO. Since nothing was processed, if Lordship could come to page 20.
Okay, let's not go into the facts now. Tell me, how are you involved in the case?
Lordship, I was served with a notice under 41A.
41.
Lordship.
Okay.
And I had appeared before the IO back then. Lordship, now I apprehend since other accused in this present FIR, some of them had been arrested also despite serving 41A and remaining others have
See, Mr. Kera, you know very well what section 41A entails.
Lordship.
If at all, if there is any reason for you to be arrested, it is incumbent upon the IO to inform you, number one,
Lordship.
give the reasons, and a consequent order of the magistrate will follow.
Lordship.
That procedure has not been, is not present here.
But Lordship,
So, where is the apprehension? In
Lordship,
fact, there is no ground for apprehension.
41A, Lordship, would operate when the offence is punishable up to 7 years. Though 379,
Okay.
but now section 3 of the Explosive Act is there. That is the only apprehension.
10 years, isn't it?
And if I can have your Lordship to page 24.
But if Mr. Khan, that explosive case, act section is involved, then why notice under section 41A has been issued?
Absolutely, Lordship. That was not required. Lordship is correct. That's because 41 is only for punishment below 7 years.
Procedure has gone awry.
I can have Lordship to page 24.
Yes.
Lordship, this is my deed of retirement. I have in the year 2021 itself, on the 24th of February, I have retired from this business. I'm no more a part of it. And if Lordship comes to page 25, last paragraph, if I may read the first 3 lines, Lordship.
Yes.
And whereas the party of the fourth part, that is me, Lordship, due to some personal inconvenience and due to difference in opinion with the parties of the first, second, and third part, expresses a desire to retire from the partnership firm. Lordship, since we had not received any CTE or CTO, and there was a phase of COVID which was going on, it finished. In the year 2021 itself, I have retired from the firm. I have got nothing to do with the firm or the business. Among others, Lordship, I pray for parity also on the ground that the other co-accused have already been granted anticipatory bail at the motion stage itself on 29th. I'll cooperate with the investigation.
Yes, Mr. Khan.
Your Lordship, the last submission was important. That
Covered case.
full bench is already granted.
Covered case.
Covered this. There's nothing much.
Nothing.
There's nothing. Otherwise, Your Lordship, a normal submission would have been.
The irony of it is this court was also part of the full bench.
Lordship.
Even if I want to,
I wanted it to fall from Your Lordship. Like
Even if
part
I
of the full page, you know, sitting in a single page.
even if I want to,
Lordship, imagine Lordship, just imagine a situation on merit. Your Lordship disagrees. Then what happens?
no, I can't. See, that there is no bar.
I thought imagine a situation.
There is no bar. Except
Judicial discipline demands
judicial discipline of propriety, but even then, see, every case has to be distinguished on its own facts and circumstances. When you say facts may be same, circumstances may not.
Lordship, we are grateful. At least Lordship is addressing that part that it can be distinguishable, but judicial discipline demands. Lordship, if I may submit one thing, nothing to do with this case. Lordship's disagreement on quashing POXO.
Yes.
Where husband and wife are living, and of course, tentatively, Lordship, if I may submit, that appears to be not judgment in consonance with law, but that has created a ripple all over India.
So what happened?
Lordship, now 2 matters are before Supreme Court. Chief Justice of India has made a statement. Lordship order created ripple in UP, in Rajasthan, in Karnataka. And now finally so that just last week the Supreme Court has issued notice trying to distinguish romantic relationship from the POXO Act. So I just wanted to tell Your Lordship, it started off from Meghalaya High Court.
But then if you recall, see, this court has I was just following precedent.
Lordship was invoking inherent power and says what will be the power. I remember, Lordship, I had argued this case and I was very strongly arguing it. So good news is this, Your Lordship, at least that thing has created a ripple effect.
The court has given its view,
Yes.
no doubt. See, it may be right, may be wrong,
Right.
all we know.
But it triggered off a discussion which is now before the Honorable Supreme Court and will be heard. Lordship, so far this case is concerned, Lordship, there's nothing much. Judicial discipline demands that.
Heard Mr. Nkira, legal counsel for the petitioner. The petitioner is said to be a partner of, what's the firm?
Mrs. Yash Kok.
Mrs. Yash Kok. Involved in, what is your area of operation?
Shalang, Lordship.
The Shalong, yes, that is the jurisdiction where you are functioning from. You are a coke plant.
Lordship. Coke plant.
No, not a coke plant.
Coke plant.
You would be a partnership.
Partner. Lordship, I was a partner until 21.
That will come later.
Lordship.
But
Lordship.
initially, that was the allegation against you.
Lordship.
Hunung to? In coke industry, wherein coke industry, for which the said partnership firm is said to be operating within the Shalang area of West Khasias district. Where is the FIR?
Lordship, we are not holding the FIR with us in the case.
That is the basis.
Lordship.
Then how do I?
Lordship, page 35 is the 41A notice which
No, that
reads about it.
this court has to refer first to the FIR. Mr. Khera, you should have been prepared in all aspects.
I'm sorry, Lordship, from next time I'll take care of it.
On what basis I'll?
Lordship, the
There must be- there must be-
41A notice makes it very...
That is true. That is true. But what is the contents of the FIR as such, which has triggered the the 41A process?
Lordship, the FIR number is mentioned in the notice under 41.
So you expect me to know what is there? I'll give you a citation. I expect you to know what is there.
Lordship.
Unu tunggu. It is the petitioner's case that he was served with a notice under section 41A of the CRPC in connection with Shalang PS case number 39/12 of 2022 under section 188. Sa akin yung section no. Pursuant to the issuance of the said notice, the petitioner had joined investigation and was questioned by the IO?
Lordship.
Questioned by the IO. However, in due course, coming to learn that some notices of the said notice under section 41A connected to this said Shalang PS case number 39 on their appearance before the IO have subsequently been arrested. The petitioner therefore apprehends that he may be arrested in such connection, hence this petition. Before proceeding with the merits of the case, the learned counsel for the petitioner has submitted that a number of accused persons, a number of applicants also involved or said to be connected with the said Shalang PS case has approached the Honorable Supreme Court for grant of anticipatory pre-arrest bail, to which the Honorable Supreme Court by order dated, what is the order?
7/8/2023, Lordship.
Order dated 7/8/2023 in special leave petition under bracket civil number 28879/2023 had directed the petitioner therein to approach the full bench of this court who is seasoned of the subject matter, Accordingly, the said petitioners, on approaching this court with relevant application under section 438 CRPC, the full bench of this court, right, order dated
29/8/23, Lordship.
29/8/2023, has allowed such petition and prayer made, and has granted pre-arrest bail to the petitioners therein. It is further submitted that the petitioner herein, being similarly situated, applying the principle of parity, prayer is accordingly made for grant of pre-arrest bail. Next. Mr. K. Khan Leonard, PP, appearing for the prosecution, has, in all fairness, submitted that since the facts and circumstances of this case are also the same subject matter which was dealt with by the full bench of this court by the said order dated 29/8/2023, in a series of applications for grant of pre-arrest bail. Therefore, there is no objection if the same if the prayer of the petitioner is allowed. Next. Accordingly, keeping in line with the order passed by the full bench of this court, the prayer of the petitioner is hereby allowed. In the event of his arrest, in connection with the said Shalang PS case number 2, the petitioner is directed to be released on bail on the following condition: that he shall not abscond or tamper with the evidence of witnesses, that he shall cooperate with the investigation, and in this regard shall furnish his mobile phone number, wherewith he shall or may be contacted at all times if so required. That he shall not abscond like that. That he shall not leave the jurisdiction of the state except with prior permission of the IO or the court concerned. He is a resident of the state.
No, Lordship. Lordship,
That he shall not leave. He shall not leave the jurisdiction of India. Except that he shall. You have a passport?
no, Lordship.
That he shall bind himself with a personal bond of 1 lakh with one solvent surety of like amount to the satisfaction of the arresting authority or the court concerned. The above this petition is accordingly disposed of.
Lordship, I'll provide the phone number for the court
Yes, I
order
think
in the order.
either you give it to the court or you give it to the IO.
I'll give it to the court.
And even to the IO Lordship better.
IO is good enough.
Because IO will be the best person.
I think I've noted that it should be given to the IO.
Lordship. Obliged, Lordship.
Obliged, Lordship.
Item number 2.
Yes.
My lord, the petitioner has mentioned the other day this matter before the other court, Justice Bhattacharya's court, saying that there is some urgency because of the Apex Court's order, my lord, of 25th July, my lord. So, my lord, I do not see anything.
Where is the order?
My lord, I have a copy of that order, my lordship.
What does this order say?
My lord, this particular PIL, my lord, suo motu PIL, taken up by the Honorable Apex Court, my lord, it falls into 3 categories, my lord. Some bail portion, some remission portion, my lord. So, my lord, the order has come in 3-fold also. So, I do not see anything urgent as going through the order. But what do my friend actually wanted to submit? The petitioner counsel, it's up to him, my lord. Because as we have been submitted, this matter has been still.
Mr. Padia must be in the other court.
My lord, may this matter come up on Monday, my lord, because Mr. N.D. Shulai, who is the leading counsel, is also unavailable today.
Oh, he's not here.
No, my lord. It can come on Monday, my lord.
Petitioner is not found when this matter was called up. Accordingly, as prayed for by the learned by Ms. Arhuli, learned GA, list this matter on Monday.
Item number 3.
But they have to file the rejoinder. my lord.
I'm praying for some more time, Lordship, to file my rejoinder.
This is with regard to
My lord, this is
Withdrawal
regarding
of
the
that exemption, Your Lordship.
Comora limestone, my lord. That withdrawal.
EPF
withdrawal
matter
of,
EPF, Your Lordship, yes. Withdrawal of that exemption.
withdrawal
that is the case.
connected to the other case.
Yes, my lord. In fact, what had happened, my lord, during the pendency of the other matter, my lord, there was a notification which was issued by the government. Now, that was brought on record before this honorable court by the government affidavit, my lord. Now, they intended to challenge that notification, my lord. So that is why this writ petition was filed.
But why, you see, why they couldn't do it in the same, petition? Filing of a rejoinder or any, any.
No, my lord, because in the earlier writ petition, there was no prayer for, because by then, when the prayer was made by then this notification was not out.
You can always file a rejoinder and with a prayer for, amendment of your prayer or.
That could have been done.
Otherwise, it's a multiplicity of.
In that other matter, Your Lordship, we challenged regarding the suspension of the mining operation, Your Lordship. In this one.
Okay, not specifically with,
Yes,
with regard to the EPF matter.
In fact, my lord, in the earlier writ petition, there was no relief sorted against the state, my lord. Sought against the state.
Only the state is a respondent here.
No, Your Lordship.
No, my lord, the PPF is also respondent. EPF.
And counsel for the petitioner has submitted that he may be allowed to file the rejoinder affidavit as the same could not be filed today. On premier, the same is allowed. How long?
2 weeks, Lordship.
This is matter of 2 weeks.
They oblige.
Allah Shukr.
Item number 2.
May it please the Lordship. Lordship will be filing a rejoinder in the course of the day, Lordship.
And counsel for the petitioner has submitted that the rejoinder affidavit may be allowed to be filed in course of the day. Accordingly, the prayer is allowed. This is not after 1 week.
I do oblige, Lordship.
Item number 3.
My Lord, I pray for some time to file the counter affidavit matter. These are ARPS matter.
Who's for respondent 1 and 2?
1 and 2 is the Union of India. Mr. Devnath is
What is this case about, miss? Tell me. You are the petitioner?
Yes, Lordship. I'm appearing on behalf of the petitioner.
Yes, tell me what's this case about?
We are seeking for 7 pay commission.
Oh. You are? Who are you?
I am the employees of ARPS Assam Rifle School.
Oh, Assam.
Light Rock.
Okay. Yes, I think that the other transfer matters.
my Lord. Along with amalgamation matter, it's already been heard by this court, my Lord.
Yes. That order will soon be passed, I think, within early next week.
My Lord.
But that will have no bearing on this, or should it? But there is, if it is a question of
State or
of a prayer for
7 pay.
implementation of these pay commission recommendation, the 5th or the 6th was already given.
6th was already given, but we were challenging on the ground that for the implementation of these 6 CPC or 7 CPC, whatever, my Lord, there has to be a budgetary allocation. Because in such cases there was no such budgetary allocations, nothing. It was only there and trying to enforce the bylaw which is made by the CBSE, my Lord. Because that bylaw also cannot be enforced, my Lord. I have already made argument in that regard, my lord, in that case, and also submitted the written arguments.
We will see. Mr. Ensign Connell, there are counsel for the respondents 3 to 5 respectively has submitted that the counter affidavit could not be filed today and has sought for some more time for the same. Mr. Devnath, your opinion?
I'll be filing, but no instruction yet to receive. I'll be filing my affidavit. I'm not the necessary party first.
You are for Assam Rifles?
Yes, sir.
Assam.
Mr. R. Devnath, CGC has submitted that, has also submitted that he will be allowed to file the counter affidavit on behalf of the respondents 1 and 2 Public Union of India. On premium, the same is allowed. How long?
After 2 weeks.
This is matter after 2 weeks.
Obliged.
Item number 4.
Yes. Have you filed?
Please, Your Lordship. No, so we'll require a little bit more time. We've received the instructions. We require just a little bit more time. 2 weeks, my lords.
Mr. All right. The respondents appearing through their respective counsels have sought for accommodation in filing the counter affidavit as the same could not be filed today. How long?
2 weeks, my lords.
Accordingly, on pyramid, the said affidavit is to be filed within the next 8 weeks. This is matter to 2 weeks.
Highly obliged.
Item number 5.
Please, Your Lordship, I beg to seek 4 weeks time, Your Lordship, since we've applied for the certified copies, so we'll need more time to prepare, Your Lordship.
Oh, that.
For unauthorized demolition of the
unauthorized
What
demolition.
about, we are still on that government...
that is still being considered. The modalities will have to be worked out because it is only not for Meghalaya, it's for the entire India. So they've made different committees and they're still deliberating on the modalities.
Would it be prudent to wait for the same, or should we dispose of this matter in due course?
Ideally, my lords, in other cases as well, courts are awaiting the outcome.
Okay.
So I'll leave it up to lordships.
Well, then in that case, we'll have to follow suit. On pre-made by the parties, this is matter after 4 weeks.
So may I pray that the interim order may kindly be extended, my lords.
In the meantime, as prayed for, the interim order will remain until the next date, until further orders.
Highly obliged.
Item number 8.
Well, please, Your Lordship.
Oh, this is for substitution?
This is for substitution, my lord.
Who is to be substituted?
The wife of petitioner number 3, my lord. He expired on 31st/7 of 2022, my lord.
What is the subject matter of this case?
This is in respect of land acquisition.
Oh, land acquisition.
Yes, compensation has not paid to the landowners, my lord. Yes, lordship.
Compensation has not been paid, as in, the procedure has been completed?
Completed, my lord. Inquiry has been conducted by the collector, my lord, and it has been sent to the joint secretary for approval. That has not been approved till date, my lord.
Why would you come to the Red Court for that?
Lordship.
Why would you come before the Red Court for that?
Lordship, because compensation has not been paid, my lord.
It's not been paid. Then you pursue with the department concerned.
We have pursued, my lord. They are not paying. That is the reason why we have no other alternative but to approach before this honorable court.
Is it so, Mr. Sen?
We've also pointed out the remedy is not here. A formal decree, a formal award is yet to be drawn up by the department. There were some intervening reasons why this did not happen. Rate was already fixed, assessment was already done. They were informed about it. they wrote to the department concerned, the deputy commissioner, contesting those rates. So the deputy commissioner sent this matter to the revenue department. It was pending there over their objection with regard to the assessment. That's the reason why time was consumed. Later, the revenue department has written to the DC rejecting their objections to the assessment, and the original assessment has been confirmed. So they are aggrieved with that. So this is at a very interim stage. Whatever assessment has been done, that will have to find a mention in the award. And if at all they have any grievance, they will challenge the award under Section 64.
No, my lord.
That is the
Section
course that we
64 will come into picture only once award has been published. my lord.
Exactly.
Award has not been published, my lord.
Exactly. So you see,
So inquiry has been conducted under Section 11, my lord.
Mr. Movin,
Lordship.
the fact remains that due process has been complied with. It is only at the stage where, as Mr. Sen has pointed out, that there was some confusion with perhaps the quantum of the.
No, that has been clarified after the inquiry, my lord.
So now what remains is for the award to be announced.
Lordship.
So that is the stage, which is a matter of course. Once that is done, once that is done, if you are aggrieved, then you also have your remedy for enhancement or all those things.
I may also add, but because of the pendency of this writ petition, they did not touch the award.
Oh.
As soon as this writ petition is disposed of, they'll drop the entire award.
See,
that is what I'm instructed by.
Now you are tripping yourself.
Lordship, if that can be recorded, my lord, that the award will be published as per their assessment. No, if it is done, my lord, then of course we are not pressing. But that is what.
This was informed to them on the last occasion as well. We've always maintained that we'll go ahead with the award.
No, Lordship, as per the.
There is no interim order here.
No, there is no interim order.
As per the affidavit
of
proposition,
since the matter was pending, they had raised an objection with regard to the entire interim procedure. Whatever procedure had been adopted, they are objecting to that. So that's the reason as a result, we thought it fit to let the court decide this issue.
No, actually, we were not actually objecting to the procedure, my lord. The only grievance of the petitioner was that the award has not been.
So we'll see. What we'll do is the court will not touch on the merit of the petition,
Lordship.
but will observe
Lordship.
That since it was stated or rather submitted at the bar, that the award is at the stage where it is likely to be published.
Lordship.
Then we'll wait for that.
Lordship.
And the petitioner, this petition will be disposed of, leaving the petitioner to resort to any recourse, in due time.
And it may be recorded. It may be recorded. The state will act in accordance with the act. That's all.
Yeah, that of course. I think
that's and time frame may be given, my lord, because this matter has been pending since 2013, my lord.
There's any time frame in the act?
Under the act, no.
2013.
Lordship.
We'll do it as soon as possible.
Reasonably, it should be.
Absolutely.
And now, actually, what has happened, a fact of the case is that, my lord, now they are planning to expand the route. Now, again, they are planning to take over the land.
You'll get more money, so what is there?
No, that is a subject matter for different controversy.
No, but off the record, my lord, I'm just bringing it to the notice of this honorable court.
We think that further enhancement or whatever. So we'll do it that way.
Lordship.
Heard Mr. A.G. Moment, and counsel very.
It's just on the issue of time frame, my lords, because in these projects, presently there are only 3 petitions before lordships. One of them is expired. There are several other people. Giving a time frame may create some sort of a difficulty because there are because the project involves several other landowners.
No, but whatever the case we see, matter pending since 2013.
So in accordance with law, as expeditiously as possible.
Yes, expeditiously.
Lordship.
Yes.
That will
expeditiously, my lord, because I may not be allowed to come again, my lord, because it will be an ambiguous word if lordship use expeditiously. If 2-3 months, my lord, then of course we can come back before this honorable court. Because it has been held, my lord, the word expeditiously, my lord.
If there are genuine difficulties, my lords.
Knowing how the the government missionaries work,
lordship,
we'll give them an outer limit of 6 months.
Lordship, that'll be fine, my lord.
Who has submitted that an application for substitution of the substitution in place of the deceased petitioner number 3 has been filed to bring on record the legal heir representative of the said petitioner number 3 with his wife.
उसको खाली सब्स्टिट्यूट करा देगा 1 month
Any objection to the?
We had filed a show cause. There is a decision of the Honorable Supreme Court which says that if there is a serious delay in approaching this Honorable Court, although CPC does not apply, I'll leave it to Lordship's fellows. I just put it on record.
No. Though there is some resistance to the said petition by the respondent, however, only with regard to the issue of delay in filing the said application, no strong objection has been made as far as the person to be substituted is concerned. This court in the interest of justice has deemed it fit to allow this petition. Accordingly, the deceased respondent petition number 3 is hereby substituted by his legal heir and representative, that is his wife. So what's the name?
Sehini, my lord. Sehini Sangma.
You filed miss case for that?
Yes.
No, ma'am. Yes, I filed.
They have filed
miss case for substitution.
So katu long have miss case. Miss case accordingly dispose of. Next. Then you have make case. Mr. E.G. Movement, counsel for the petitioner, has submitted that the grievance of the petitioner in this raised in this petition is with regard to the process and procedure followed, wherein the land of the petitioners was acquired for construction of Lane, Shillong Nongstoin, section of National Highway 44, and Nongstoin Rongjeng, Tura Road, and the phase A, capital A, and the code of SARDP, kini capital baru. Though it is admitted that the procedure as per the Land Acquisition Act, is it the Land Acquisition Act or the earlier Act?
Lordship, 1894.
The Land Acquisition Act, 1894, was duly followed. However,
no, it is lapsed. Just correction. It may have been started under the old Act, but since the award has not been drawn up, that has already lapsed. So the proceedings now will be tried under the 2013 Act. Okay. That has already lapsed.
Yeah, it should be.
What?
However, in course of time, since the new Act has come into place, the procedure followed by the, what is the full form of the new Act?
Right to fair compensation. I'll just have it. Rehabilitation.
I thought it's at the tip of your tongue.
Right to fair compensation.
Such a long. So, then under the new Act, that is the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013, which deals with matters of acquisition and compensation. The grievance of the petitioner is only to the fact that the award is yet to be published, which according to Mr. SN, that senior GA, then appearing for the state respondent, is a procedural matter, and at this juncture the award is likely to be published at any point of time in accordance with due procedure. The parties agreeing not to agitate the issues raised in this petition on merits, has however consented that this petition may be disposed of with specific direction to the state respondent to complete the procedure, particularly to publish the said award as expeditiously as possible. Accordingly, as submitted, the respondent the state respondent is hereby directed to complete the process, including publication of the said award, possibly within 6 months from the date of this order. The above, this petition is disposed of. This will, however, not prejudice the rights of the petitioner to approach any legal forum if and when agreed to by such proceedings. The above, this petition disposed of.
Will you please close? Similar order for the other items.
Similar order.
Similar order.
Watch it.
That is in
Number
9.
9, 8 and
Same order. But here also a substitution.
No, there's no substitution.
Kamu kan lihat tengah main ni.
Highly obliged.
Item number 12.
Yes.
Please, my lord, as per Lordship's order dated 2/8/2023, the petitioners were supposed to take steps to implement the
Maharaj, we have filed criminal case number 55 and 56 in order to include A3.
Yes. You have not received copy of this petition?
My lord, here what has happened is on the last occasion, your lordship recall that there was some confusion as to the matters, wherein the learned senior was supposed to sit with the CBI. Now, I've prepared a small chart which matters were supposed to implement and which matters were not necessary, which quite implemented.
But this petition is here.
My lord.
As far as this,
My lord, your lordship has passed an order in all the matters. In fact, we are paying for implement only in 2 matters.
Okay, now coming to this this petition now, petition number 36.
36.
Are you required to be implemented?
No, my lord.
You are not required.
Not required. 36.
So now you have filed this petition.
Maharaj, we are not pressing it then because there was an order to the effect we had to, and now if they do not want to be impeded, we are fine with it because as it is, we are not necessarily fighting this one.
exactly. Heard Miss S and letter counsel for the petitioner, who has submitted that the application for implement of Srimati Amika I. Lindo, the accused number 3 in the, before the trial court, not being necessary, the said application is not pressed for. Accordingly, the Miss case number 55 2023 is hereby disposed of as not pressed. Okay, now next.
That's criminal petition number 37, my lord.
Now, what about 37?
Yeah, my lord, we are necessary. We are required to be pleaders parties.
Criminal Miss case number 56, my lord. That means.
Heard Miss S.R. Leonard, counsel appearing for the petitioner, who has submitted that an application to implead Srimati Amika Ailingro, the accused number 3 before the trial court, has been filed before this court with prayer we pray to implead the said person as party respondent in these proceedings on the ground that her presence would be necessary for proper adjudication of the main application. Mr. CCT Sangma, Leonard Counsel. You file your power, Mr.
Well, the moment I've been implemented, I'll file during the course of the day, my power.
Has submitted that he is accepting notice on behalf of the said Miss Amika Haringdo, and though power has not been filed in this regard, has however on instruction submitted that there is no objection to the said petition. Accordingly, this petition is allowed. The Srimati, I missed there. Miss Amika Ailingdo is hereby pleaded as respondent number.
Will be respondent number 2, my lord.
Number 2.
Number 2.
Respondent number 2 in these proceedings, in the main proceedings, that is in criminal petition number 37 of 2023. This case number 56 of 2023 is hereby disposed of accordingly. Registry is directed to do the needful. So you file your power next day?
Well, during the course of the day, I'll file my lord.
So that dispose of the 37.
37.
Now,
my lord, that is in item number 14, criminal petition number 70.
70. You are not here in this case, are you? No, you are not.
Mr.
Ponti, you file it, Lordship. There's a Miss case, we have Miss case 57 in the criminal petition 70.
Same.
Yes, Lordship.
Would be also
Same order.
Same order, Tuma. So either change not tangi karting jo ki
Yes,
council. So that would dispose of item
13 and 14.
13, 14 and 13 and 14 no.
13, 14.
No. 14 and 15.
Malab. Now 15 here, Malab.
15 we
Though an
haven't
order has been passed by a lordship, but no application has been filed. So in fact, Malab, we are not even required to be made as party.
So,
Item number 15.
so 15 is not required.
not required. No.
So what will be the next step now?
No, Malab, here, whatever in lordship in the next day. I'm praying for some time. I'll file an affidavit, bringing on record the subsequent orders passed by the learned trial. Here,
There was
Malab,
no stay in the proceedings.
no, Malab, here, what has happened is that they have challenged an order where the trial in me has been postponed. When in fact, for the other two accused, trial has been proceeded.
This is proceeding.
Now, Malad, here they have annexed only the specific order, Malad, which the trial has been postponed. The subsequent orders was never brought before your lordship. Or for your lordship, that I would like to bring all those by way of an affidavit. All the subsequent orders passed by the lower trial court.
Mr. Sawa, you have not been empowered, so how do you?
No, that's why I filed my power during the course of the day.
We'll take up this matter on Tuesday then.
Malad.
Tuesday? Yes, Mr. Can you hear?
1 week after 1 week, lordship.
How week?
On pre-made by parties, lays this matter to 1 week.
Madam, we have concluded our arguments in the main matter on criminal petition number 36.
But now I don't know. See, since
Madam,
since the new party has come in.
No, Malad, in 36.
Madam, in 36, there is
36,
no new
okay,
party.
36,
I'm not.
And 37 we haven't even begun yet. So if my lords may kindly dispose of as per my lords directions, if my lord may complete hearing 36 first, and then once we address on in 37, then 8th Council may assist my lords.
But okay, so matter is fixed next week. So Miss, you have to be prepared to, respond, because I think it's your turn to respond.
Exactly.
Fine. So next date then.
Deeply.
Grateful.